Yes. So pleadings are complete?
Yes, Lordship, it's completed. In fact, we are prepared for admission hearing. Even Lanet AG is appearing online also.
Yes. Yes. Okay. So pleadings are complete? Then we can decide for admission hearing in the next date, immediately after the vacations. Isn't it?
If your Lordship can
Because
hear,
what is the situation now?
my Lord, it's still that the order still stand. That
Okay, still
dissolution,
stands,
yes, still stands. Yes.
So it's now, and the order is for 6 months?
Yes,
6 months.
And what is the date of the order?
7/7.
7/7 for 6 months. So there's still time. We'll list it immediately after the this thing
My Lord,
vacation. We can fix a date.
Can I have dates?
Okay, yes.
October 14 or 13?
13, 14, my lord, I am not available. I am in Supreme Court, my lord.
14?
Okay, so
13th
we'll
and
fix a
14th,
date.
13th and 14th. I am in Supreme Court.
My Lord, any date on second week, on
any date
13,
before that, ma'am.
between 13 to 17, any day, when AG is available.
When will you be available?
Before that also we can do it.
After the vacations.
It's holiday.
After the, when it is
So vacation is up to the 3rd. So 6, 7, 8,
Third.
9.
we can do it. We can do it on 8th or 9th.
My Lord, 8 and 9, I have arbitration in Guwahati. It's already fixed. What about on 6?
On 6th, immediately after opening. I can't hear you. Yes.
My Lord,
Have some
can we have
personal
between
problems, my Lord,
13 to 17? Any date on 13 to 17?
16th.
Yes, fine.
16th. Okay.
My lord, I was ready to argue the matter. If my learned friend is ready to argue the matter today, I can argue the matter today also. It will not take much of time.
Okay, since pleading is complete, both the parties are present. Let's hear the matter. Yes.
Yes. So, my Lord, can I start?
Yes.
My Lord, this matter pertains to dissolutions of Chakma Autonomous District Council. That is which we challenge. My Lord, allow me, a very brief fact is there. So, if you come straight to Annexure 1, so it starts from...
So basically it's challenging the order
of the governor.
Of the governor, wherein he had dissolved. Let's see the order.
My Lord, it starts at 44, page number 44.
And then we'll see the reason, page 44, the reason for dissolution
reason
also will be
political
given there,
instability.
then we can discuss from there, isn't it?
Yes.
Wait, page 44. Yes, 07 7/2025. Let's
Allow
see
me-
the order. It must have given the reason for
Yes,
passing the order.
only one reason. May I kindly read?
Yes.
Whereas Mr. Molin Kumar Chakma was removed through a no confidence motion from the post of Chief Executive Member Chakma Autonomous District Councils on special sitting of the 11th Chakma Autonomous District Councils on 16/6/2025. And whereas upon the removal of Sri Molin Kumar Chakma as Chief Executive Member CEM, Mr. Sri Lakkhan Chakma staked claim to be the third CEM of the 11th CADC, and whereas the Honorable Governor is of firm opinion that the constant political instability, this is the reason,
This is
political
the reason.
instability is extremely detrimental for the CADC and is certainly not what is intended by the 6th schedule to the constitution in India, which envisions the effective administration of the tribal areas for the good of the people, and whereas opinion of the councils was obtained, and whereas as provided under para 16.2 of the 6th schedule, the Honorable Governor is satisfied that administrations of CIDC cannot be carried on in accordance with the provisions of the 6th schedule. Now, therefore, in exercise of the power conferred by para 16.2, read with para 20 BB of the 6th schedule to the Constitution of India, the Governor is pleased to assume to himself all functions or powers vested in or exercisable by Chakma Autonomous District Council. Further, the Governor of Mizoram is pleased to declare that such functions or powers shall be exercised by Deputy Commissioner Longklai on his behalf with immediate effect for a period of 6 months or until further orders. Well, basically, I have 5 grounds. Before I go further, allow me just to point out. One is that the petitioner having absolute majority are entitled to form government as provided under Rule 22 of Chakma Autonomous District Council. That is my first point. Number 2, this impugn notification has no legal sanctity. It's lack of constitutional authority.
Okay.
Number 3, the governor has acted unreasonably, discriminatorily in violations of Article 14. And number 4, the governor acted in contraventions of the advice of the councils of ministers.
What? Here it says that on the advice of the Council
No,
of
acted
Ministers.
contrary to the advice of the councils of ministers.
Okay.
Because the council of ministers advised him to give a chance to stake claim, to form a government, opportunity to be given to the petitioners. And number 5, in view of the decisions of many Supreme Court decisions in many judgments, including recently you passed it, Vizir Sangha case, that it is the constitutional mandate to conduct floor tests. Recently, your Lordship also passed. These are my basic, though I have some other points. So just,
Okay.
so my Lord, before I start, allow me the very short brief fact. So my Lord, this case is, so I started this, the story started from actually from 5th June 2025. This, so here 14 members, MDC members, so submitted request to conduct special meeting on 5th June by 14 members. If you kindly see page number 29.
29.
Yes. So these are 14 members. They consist of 2/3 of majority in the existing 19 members. So they requested to the chairman to conduct a special meeting. So in view of this letter, requisition letter, the chairman issued notification on the same day. So special meeting has to be conducted on 16 June.
Where's the 16 June?
16 June, it is notification, page number 21, annexes 2.
21.
31.
31.
Annexure 2. So here, special meeting has to be convened on 16 June. So I'll just come straight. What happened on 16 June? So 16 June, notice of no confident motion was issued. So then that incumbent Artwell CEM lost the majority on 16. And this in this special assembly at 10:30 a.m. So then new ZPM legislature party was formed on 16 June itself.
New party was formed on 16.
No, that is
what
ZPM
happened?
legislature party. If you kindly see 34, page number 34.
So this is what 34 is what happened on 16 June, is it?
16 June, he was removed. That the Answell CM was removed.
Okay, so on 16 June, page 34 happened, is it?
Yes.
What
So
is page
petitioner number
34?
1 was elected as the leader of the PM legislature party.
So page 34, in page 34, who is this leader?
That
Lakkhan
petitioner number
Chakma.
1. Yes.
Lakkhan Chakma
Yes,
was
petitioner number
elected.
1.
Lakkhan Chakma is the petitioner.
Number 1.
Okay.
So the rest of the one who supported him are in the petition number 2 to 415.
Petitioner number 1 was elected.
Yes.
Previously, who was it?
Mohin
Previously,
Kumar Chakma, that he's not there. He's not there in the petition, in the case.
Okay.
He lost the majority.
He's not the respondent, he's
Yes, not
nothing.
at all. Because, see, they have absolute majority.
Who has?
This
The
ZPM
petitioner,
legislative
the
party.
petitioner.
Yes, petitioners. See, my lord, if you
So
see,
the petitioner has absolute majority. You found that out on
My lord,
16 June.
yes, my lord,
You
kindly
found
see
out that on 16 June only. Huh?
kindly page number 35. These are all
35.
who supported.
So
Yes.
35. So because of 35, 34, you have the majority.
Yes, my
Isn't
lord,
it?
remember that it is 20 members MDC, total members of the MDC is 20. Out of 20
members,
we
you
have 16 majority.
Okay.
Interestingly, that the by-election was conducted recently. We can see from the counter affidavit filed by respondent number 4 also. Now we have become
Who is respondent number 4?
CIDC,
CADC is represented today?
Mary.
I'm representing
You are the counsel?
CIDC. Yes, my lord.
You are ready for hearing?
Yes, my lord.
So my lord, in their counter affidavit, they submitted that now we have one more member. Now we have become 17, absolute majority.
Out of 20,
20.
petitioner has 16 majority.
Now 17.
Now 17. When? When was it 17?
When election,
No,
you'll
you
see
tell
in
me,
their
you tell me.
affidavit.
Where?
My lord, by-election was held on 23/7/2025.
We are talking about 16 election, 16/6. 16/6 he has this. On 16/6 he has
My lord,
16 majority, isn't it?
yes.
Then when was it 17? It increased to 17 on?
My lord, in their counter affidavit, they have enclosed.
But you should know, you read the counter.
Yeah, I have the copy here, my lord. Annexure number 2.
17 on, 17 numbers on.
My lord, that on 8 August, certificate of election was issued on 8 August 2025 to one Mr. Dinesh Moy Chakma.
To 2025.
Yes, 8 August 2025 from ZPM party. Now we have 17 members.
Oh. So, but the order was, the impugned order is when?
7-7.
7/7.
This is
so
after filing this one.
So leave it. The impugned order. So you don't talk about this. We are talking about only the order, impugned
Yes.
order. That was
But this-
before 8/8, isn't it?
7-7.
So
Yes.
it is before the increase of 17 numbers.
Yes.
So we don't have to look into this. We have
Yes.
to see the order 7/7.
That's
Don't confuse the court.
yes. No, just to appraise the court.
No, I'm not interested in all that. I'm just looking at the impugned order. Yes.
So then after that, so we stake claim. So then they, very interestingly, this annexure number 10,
What is annexure number 10?
page number 42.
Annexure number 10 is?
Opinion of the councils of ministers.
Okay, Council of Ministers. So one of your points was the decision of the governor was against the opinion
Yes.
of the Council of
Yes.
Ministers.
Yes.
So what is their opinion?
See, here that the decisions of the governor, allow me to read on
The annexure 10,
Yes.
please read.
Additional Secretary, Political and Cabinet Department may please find enclosed here with a copy of Honorable Governor D.O. letter dated such and such addressed to the Honorable Chief Minister, where it is stated that the Honorable Governor wishes to assume to himself all of the function vested in the Chakma Autonomous District Council under Para 16.2 of the 6th Schedule, copy of such and such, due to political instability. In order to invoke this provision, consultation of the Councils of Ministers is required under paragraph 20 BB, and therefore may take action he considered necessary in his discretion. Commissioner and Secretary to the Chief Minister has verbally conveyed instruction of the Honorable Chief Minister that has decisions of the Councils of Ministers be obtained by way of circulation due to urgency and confidentiality of the matter. She is therefore requested to kindly take necessary action for placing the matter before Councils of Ministers by way of circulation. And the next one is the decision of the Councils of Ministers. Subject: proposal for obtaining opinion of the Councils of Ministers for impositions of governor rule within the Chakma Autonomous District Council. As per provision contained in Rule 15 of the Government of Mizoram, Transactions of Business Rules 2014 as amended from time to time, the above proposals of District Councils as Minority Affairs Department was circulated amongst the members of the Councils of Ministers for opinion. The Councils of Ministers is of the opinion that the new claimant for the formations of a new councils be afforded an opportunity by the governor. However, the Council of Ministers is willing to accept any decision made by the Honorable Governor, as it is discretionary power of the Governor to take action as he considers necessary. Here, the Councils of Ministers is the opinion that the new claimant for formations of a new government be afforded an opportunity by the Governor. So, to give opportunity to form a government.
But there's a however, big however.
Yeah, however, Manoj, that is not the point. This is the query. This is something like you applied RTI Act. So in the last para, it's always written that if you're not aggrieved, you may go to appeal authority or something like you invite for a dinner.
Anyway, so
yes, if you're not,
according to you, it was
they acted in contrary to this decision. So this is the fact. Then it comes the impugn notification. This is a very brief fact. So my lord, my point to elaborate first point, the petitioner having absolute majority in view of Rules 22 of Chakma Autonomous District Council 2002, my lord, that CRDC CCP rules will be required.
Yes.
My lord, it is at 14, page number 14.
Page number?
14. Rule 22. Lordship, are we there?
No, not yet.
Formation of
Wait,
executive
rule
committee.
number 22.
22. Chapter 5.
Yes.
So, my lord, it is admitted.
It's page number 22.
Yes,
Rule number 22.
Rule number 22. In my book, it is page number 14.
That we are not on the same
my
page,
Lordship,
okay?
yes.
Not the same book.
But you're in chapter 5, Your Lordship?
Yes. Rule number 22.
Yes. May I read, Your Lordship?
Yes, please.
There shall be an executive committee of the district council with a chief executive member at the head and 5 other members of executive members to exercise the function herein after specified. And rule number 22 is my point. The executive committee shall be formed by the largest legislative party having a majority of elected member in the district council. The leader elected by such legislature party shall be appointed as chief executive member, provided that in case he is not an elected member, then unless such leader is elected as a member of district council within 6 months from the date of his appointment, as such, he shall cease to be the chief executive member and to continue as such. Lordship, even recently also, that Vizir Sangha case, you held this provision also. I will be relying also. My Lord, this admitted position that out of 20 members, we have now 16 members. And you have seen in that also that those who support, when the petition number 1 stake claim to the governor were supported by that, it was not denied also. In their county affidavit also, it was not denied. Since it is not specifically denied, it should be admitted that we have absolute majority. So then we...
So as per Rule 22, you have the absolute majority and you should be appointed. That's your case?
Yes,
Okay.
this is my case. This is the rules, the only rules for administrations of CRDC, and we have been using this one, and there is no other rules. And So, my lord, this is my one point. And my lord, there is one judgment I don't need to reiterate, but I just want to refer that when there is a particular thing should be done, it should be done in a particular. I have furnished also. I will not elaborate the judgment also, because
Just give the citation. If you want to refer to this, then
Yes.
give the citation at least.
no, that is actually everyone we refer. Then I can furnish it also. I have.
Okay, so
I
you
have-
don't want to refer, but I'll have
I
to
want
see
to
now
ref-
what is it, then I'll have to find out what is that judgment you're referring to. So at least give the citation even if you don't read it.
Yes, my lord. Can I just citation is 1999, volume 8 SCC 200. That is where a power is given to do a certain things in a certain way. The thing must be done in that certain way, in that way only, not other way, because that judgment was derived from the very old judgment, Nazir Ahmed 1936. It is there in the citation of itself. And it was
1999, 8 SCC 2000, 2000.
266. 1999, volume 8, SCC 266.
Oh.
It has been followed in many judgments. And allow me to point out the latest one referred to.
Yes.
2021, volume 6, SCC 707. That judgment, when there is, yes, the power is given to do something and it has to be done in that particular. That is one of my first point. And my lord, then my second point is that impugn notification. If you read that in impugn notification, it is very clear. It has been issued on the grounds of political instability. In fact, it is their grounds also, because there have been change, 2 times change in the political.
2 times change?
Yes. That is it is very clear here, it's political instability. And my lord, if I would like to take you to this one, the last para
Of what?
of the impugn notification, page
Page?
number 44.
44.
Yes. So the preceding paragraph is due to political instability, and here now, therefore, in exercise of the power conferred by para 16(2), read with para 20(bb) of the 6th schedule to the Constitution, the governor of Mizoram is pleased to assume to himself. The provision relied by the governor in this notification is 16(2) and 20(bb). Because here my submission is that the governor has the power to declare governor or whatever, only which has been specifically mentioned in 20(bb). If you kindly see 6th schedule,
20 BB.
20(bb).
So he has the power under 20 BB, that
Because
you admit.
yes, but in 20(b), my point is that there is no provision to declare on the grounds of political instability. Specifically mentioned, there are some paragraphs specifically mentioned.
Okay.
And if you kindly go to 312 of the 6th schedule.
Wait. Okay, under what grounds can the governor pronounce governor's
Yes.
rule under Article 20 BB? That
Yes,
is what
yes.
we're going to look into. Huh?
Yes. Here the last para, it is there
Wait. Last para.
in page number 312. Here there are the lists in which the
20B.
governor can exercise his function.
20B, isn't
20
it?
BB. Because this is the provision in the in-green notification, this has been referred, 20 BB.
Okay, read 20BB.
Yes. So 20 BB, these are the governor in discharge of his function under paragraph 2 and 3 of paragraph 1. This is one list. If you kindly go to the 6th schedule, para 1, sub-para 2 and 3 and para 1, it is there. But there is no such political instability.
And para 1, 2 and 3.
Yes.
Para 1, 2 and
2
3.
and 3.
Yes.
Yes, that's the very first page. Para 1 is in regard to scheduled tribe. Then regarding division of the area. And number 2 is that inclusion, exclusion of the constituency and creating an autonomous district, such and such. And number 2 is, because here only para 2 and 3 of para 1, wherein the governor can discharge his function, can exercise his discretionary power. If you look back again, yes, sub para 1 and 7 of para 2. If you, yes, para 2, sub para 2, in respect of 1 and 7 only, the governor
You
can
should have highlighted the points, isn't it?
Yes.
Anyways. 1 and 2 and 3.
Yes.
2 and 3. Then
in para 3,
para 3.
only in respect of para 3. That is in respect of to make
Constitution of district courts. Para 3 is power of district council.
yes,
Is it?
yes,
And this para 3.
and para 4 in respect of para 4, in respect only in sub para 4.
Para 3 is sub para 3.
Yes,
Sub para 3.
yes,
Wait, para 3, sub para 3 will be where? All laws
Yes.
meet under this.
Take
So
number
regarding the
294.
laws,
yes,
isn't it?
yes.
Then
Then para 4,
sub para 4 of para 4.
4 only.
What is sub para 4? The regional council or district council, as the case may be.
Yes,
This is regarding rules, regulations.
yes.
Huh.
And para 5, there is no such power given in para 6.
Para 5. Para 6 is
Yeah,
what?
para 6 in sub para 1. It's regarding establishment of primary school and dispensary market and ferries, road, transport and all. There is no such political instability wherein the governor is empowered.
Okay, what about 16.2?
16.2 is general provision. Yeah, my lord.
20 BB and 16.2.
Yeah, my lord, just before I go, in all the list, there is no such power being given to governor to declare this of on the grounds of political instability. This is my submission. If it is there, my
Under
opinion
20
council
BB.
can-
Under 20 BB, nothing.
Yes. And his 16 is important.
What about 16.2?
16.2 is important.
What is 16.2?
My lord, it's page number 312. Because in 16.2, the governor has been empowered in respect of what we have stated in those specific paragraphs. And in
Wait, 16.2 is where in
313,
313.
just below that one, just next to that page.
See, I think we should look at the constitution. You have given me this because maybe to make it easier, you have
This, I printed out
just
from
a
the
sec.
constitution.
You have printed out. I think it will be easier.
313 is 16.2.
Page 313. (20B). Page 313. Just find out
Yes.
what is this. No.
Yes.
Yes, Court Master, look this side. Tell him to mark. (16.2). You're saying this is 16.2, but where's the 16?
And just above that, it starts from
2.
307.
Wait. Okay, yes.
My lord, allow me to read from 16 itself.
Yes, 16.2.
Yes. Can I read 16.1 also?
Okay,
Which is
yes.
continuing. Dissolution of a district or regional council. The governor may, on recommendations of a commission appointed under paragraph 14 of this schedule, by public notification, order dissolution of a district or regional council. Number 1, direct that a fresh general election shall be held immediately for the reconstitutions of the council, or B, subject to the previous approval of the legislatures of the state, assume the administrations of the area under the authority of such councils himself, or place administration of such area under commissions appointed under the said paragraph, or any other body considered suitable for him for a period not exceeding 12 months, provided that when an order under clause 1 of this paragraph has been made, the governor may take the actions referred to in clause number B of this paragraph with regard to the administrations of the area in questions pending the reconstitutions of the councils on a fresh general election, provided further that no action shall be taken under clause B of this paragraph without giving the district or regional councils, as the case may be, an opportunity of placing its view before the councils of the state. This is B, is what the point the governor relied. If any time the governor is satisfied that a situation has arisen in which the administrations of an autonomous district councils or regions cannot be carried on in accordance with the provisions of this schedule, he may, by notification, assume to himself all or any of the functions or power vested in or exercisable by the district councils, or as the case may be, the regional councils, and declare that such functions or powers shall be exercisable by such person or authority as he may specify in this behalf, for a period not exceeding 6 months, provided that the governor may by a further order or the orders extend the operations of the initial order by a period of not exceeding 6 months on each occasion. Every order made under sub-rule 2 of this paragraph, with the reasons thereof, shall be laid before the legislatures of the state, and shall cease to operate at the expiry of 13 days from the date on which the state legislatures first sits after the issue of the order, unless before expiry of that period it has been approved by the state legislature. So here the point is simple, that it will be for 6 months. It has to be laid before the legislature, and it has to be approved by the legislatures. This is the thing. But what is important is that there are some lists, specific lists, wherein the governor can proclaim these governor rules, as we read one by one. So there is no contention on their part that this is the provision in which the governor can proclaim dissolve the exercise discretionary power. This is my point. So, my lord, I have one judgment
Okay, let's see a judgment, because I'm not getting your point. The 16.2 is there, it's clear. Okay, leave 20 BB, but 16.2, you have just read that. But you have a judgment, huh? Let's see
Yes,
the
yes.
authority.
My lord, my point is that in 20 BB,
20 BB, leave it, but 16.2, you have just read where the
Yes.
governor can exercise his
that will make it clear that the
discretionary power,
interpretation.
huh? So let's read the authority.
So, my lord, just before I start, that very brief fact of this case is that there is allegations of corruptions against CEM and some MDC members in autonomous district in Assam. So then action was taken, and the governor issued notification dissolving that their autonomous district council. And then they challenge it, and this is the case. And then the issue in this case is that the power of the governor in respect of that 6th schedule, particularly declaring in view of that 20 BB and 16.2 also. And my relevant portion is that it starts from 46 paras 46.
Yes.
The satisfactions of the governor under paragraph 16.2 of the 6th schedule, because all over Northeast, the 6th schedules is applicable. It's it is applicable to all the autonomous district councils in the Northeast India. Then the satisfaction of the governor under para 16.2 of the 6th schedule is subjective satisfaction. Such satisfaction cannot be subject to scrutiny in light of the objective test. The parameters of the judicial scrutiny in a case like this are within narrow confines. It is also necessary to bear in mind the purpose contemplated in paragraph 16.2 of the 6th schedule and the connotations of the word is satisfied that a situation has arisen in which administrations of autonomous district councils or region cannot be carried out in accordance with the provisions of this schedule. And there some Supreme Court judgment has been taken. Para 47, Supreme Court had occasion to consider the scope of judicial review in regard to the action taken under Article 356 of this Constitution in case of State of Rajasthan versus Union of India, All India Report 1976, Supreme Court case, page number 136. Beck Chief Justice in Para 63 of the judgment quoted that the following passage from Tagore Law Lectures on the Union and the State relation delivered by Mr. Setalvat. The constitution machinery in a state may fail to function in numerous ways. There may be political deadlock. The government of a state can also be regarded as not carrying out in accordance with the constitution in cases where a ministry, although properly constituted, acts contrary to the provisions of the constitution or seeks to use its power for the purposes not authorized by the constitution. The governor attempts to call the ministry to order have failed. There could also be a failure of the constitutional machinery where the ministry fails to carry out the directives issued to it validly by the Union Executive, the exercise of its power under the Constitution. The learned CJ in Para 75 observed, if it is actually stated on behalf of the Union that an action was taken on a particular ground which really falls completely outside the purview of Article 3561, the proclamation will be vitiated, not because the satisfaction was challenged and called in question on any ground, but because it was admitted to be on matters outside Article 3561. Chandruchud J, as then he was in Para 124 of the judgment, stated that it is for the President to judge whether a situation of the particular description has arisen, necessitating the issuance of the proclamation for assumptions of all of any of the power mentioned in clause number 1, B and C of Article 3561. He is expected that ought to judge fairly, but we cannot sit in the judgment over his satisfactions for determining whether any other view of the situation is not reasonably possible. So long as the reason, if any, are disclosed, given for the action proposed or taken, bear a reasonable nexus with the exercise of the particular power, the satisfactions of the President must be treated as conclusive. It will then not be open to judicial scrutiny if, however, reasons given are wholly extraneous to the formations of the satisfaction, would be open to attack that it is vitiated by legal malafide. In the judgment of Bhagwavati J, In the para 137, page number 1404, it was stated as follows. Satisfactions of the governor that a situation has arisen in which the government of a state cannot be carried on in accordance with the provisions of the Constitution is a concedent precedence which must be fulfilled before the President can take action under Article 356, Clause 1. The learned judge stated in para 144 as follows. We must make it clear that the constitutional jurisdictions of this court is confined only to saying whether the limits on the power conferred by the Constitution have been observed or there is transgressions of such limit. Here the only limit on the power of the President under Article 356, Clause 1 is that the President should be satisfied that a situation has arisen where the government of the state cannot be carried out in accordance with the provisions of the Constitution. The satisfactions of the President is a subjective one and cannot be tested by reference to any objective test. It is deliberately and advisedly subjective because the matter in respect to which he is to be satisfied is of such nature that its decision must be necessarily be left to the executive branch of the government. It cannot, therefore, by its very nature, be a fit subject matter for judicial determinations, and hence it is left to the subjective satisfaction of the central government, which is best in the position to decide. The court cannot in circumstances go into the questions of correctness, adequacy of the fact and circumstances on which satisfaction of the central government is based, but on till it is certain that if the satisfaction is malified or is based on wholly extraneous and irrelevant grounds, the court would have jurisdiction to examine it, because in that case there would be no satisfactions of the President in regard to the matter in which he is required to be satisfied. The satisfaction of the President is a condition precedence to the exercise of power under 356 Clause 1, and if it can be shown that there is no satisfactions of the President at all, the exercise of the power would be constitutionally invalid. My Lord, these are, because the power of the President and the Governor are one and same, only the difference is that the article. So,
Yes.
and my Lord, I'll just, para 49, Fali Ali Judge restated in para 203, even if an issue is not justiciable, if the circumstances relied upon by the executive authority are absolutely extraneous and irrelevant, the courts have undoubtedly power to scrutinize such exercise of the executive.
So you have to show that the order is malafide and based
Yes, my
on
Lord.
extraneous or
Yes, that is what
relevant
I'll come
considerations.
to ground number 3.
That is that's a reason why
Yeah,
you're
my Lord,
reading the judgment,
but-
isn't it?
yes, but my
only
Lord-
on these conditions.
My Lord, allow me para 51. Here, if that's
51,
the crux of the case in this Assam Autonomous
Okay,
District Council.
51.
Here, this is the reason for setting aside of the governor order. The governor must be satisfied that a situation has arisen in which the administration of Autonomous District Council cannot be carried out in accordance with the provisions of the 6th schedule. This would mean breakdowns of the constitutional machinery in the Autonomous District. None of the ground relied on by the respondent have any nexus with any act violative of the provisions of the 6th schedule or user of its power by the councils for the purposes not authorized by the provisions of the 6th schedule or failure to carry out directives. If any issue to it validly, the state government in exercise of its power under 6th schedule of any other aspect arising under 6th schedule. Some of the grounds may indicate failure, but partially or fully in providing good governance or administration in the autonomous district, but it cannot be said that these grounds have any relevant provisionable connection with the satisfactions of the governor that a situation has arisen in which the administrations of the administrative district cannot be carried on in accordance with the provisions of 6th schedule. The mind of the government is also clear from noted that 9/11/1992 of the Commissioner Secretary HAD indicating that the functions of the council was in an unhappy state of affair, and the cabinet decision dated 26/11/1992 and the cabinet discussed about the administration such and such and approve assumption the functions of the power of Karbi along district council by the government as per the provisions of para 16(2) of the 6th schedule to the constitution. It is clear that neither the secretary nor the government was satisfied that administration of the district by the council cannot be carried on in accordance with the provisions of the 6th schedule. The notification dated 27/11/1992 is therefore vitiated by non-applications of mine and unreasonableness. This is notification is that governor notification. The decision is one which has no reasonable person reasonably instructed in law can arrive in the light of the grounds as facts averted to. The notification dated 27/11 is therefore vitiated, and it is based on matter outside paragraph 16(2) of the 6th schedule and is beyond the power of the governor. In innovations of para 16(2) of the 6th schedule for the reason extraneous to the purpose contemplated therein would amount to colorable exercise of power. Notification dated 27/11/1992 is therefore vitiated and cannot stand. And point answer in favor of the petitioner. Here, my lord, the order of the High Court is that in respect of the corruption case of that alleged to be committed by MDC members and all, since it is not in the list in 16(2), so the governor cannot make any declarations, cannot pass any order. It is outside the purview of the 6th schedule, and also it is coupled with extraneous and malified intention, and it was set aside. My lord, my point again, let me just go back to 20 BB, because 20 BB is the circumstances, the situations in which the governor can exercise jurisdiction, discretionary jurisdiction. My submission, my point is that here, if you read that notification 77, the reason why this notification was issued is that because of political instability, because two times there have been a change of two governments. Because of that, there is political instability. Because that is my point is that in 16(2), there has to be that the statement or any grounds in which the administration cannot be carried out in accordance with the provisions of 6th schedule as stated there. But in that notification, it is absent, totally absent. Because I have read specifically one by one. That is my point.
Okay. Then next.
And the next is that the governor has acted in violations of Article 14, acted unreasonable. My lord, my submission here is that I have mentioned in my grounds also, ground number C, they have not averted. There, if you see in Lai Autonomous District Council, there have been a change, 5 times change of the government in that the same 11 LADC, that very same 11, there have been 5 times change, and in that situation, the governor was very hurried to call for the government, for formations of the government, and also without conducting floor tests, without setting aside the orders of the appointment of the actual CEM, and directly pass an order to appoint the new CM. So that is, but in this case,
No, concentrate on this case.
yeah, no, but I have to submit that unreasonableness. But here in this case, only 2 times. It happens only instability, happened only 2 times.
You concentrate on this case.
Yeah, my lord.
So what happened?
But I have to
So
rely-
you're saying that this notification is unreasonable.
Yes.
Is that your point? Okay.
Yes, unreasonable. My lord, but what I have stated is, in my petition also I have highlighted that is very valid. Because the actions of the governor, it is malified, unwarranted. This is the point.
So, then next.
Yes, my lord, that is. And again, number 4 is that the governor acted in contraventions of the decisions of the advice of the councils of ministers.
That you have pointed out. No?
Yes, I have pointed out. I have read the lordship again.
So you have any authority on that
43.
point?
My lord, I don't have, but it is very clear, and I have Nabam Rabia, I have, and also
So you are relying on
yes,
citation
153.
153. What?
That Nabam, I have given.
What is the
court master.
citation?
Nabam Rabia versus Arunachal Legislative Assembly, 2016, volume 8,
2016, volume 8.
SCC
Oh,
1.
oh. Para 153.
Para, it starts from 153 till 155.
Yes.
Just only 3 para. May I read 153?
Yes, yes.
Though the debate could be endless, yet we would consider it opposed to avert to the decision rendered by this court in Sardar case and Shamsher Singh case. Insofar as Sardar case is concerned, this court had held that the president or the governor, as the case may be, would pass an order only on his personal satisfactions. In the above case, this court, while examining the case of the employee under Article 311 Clause 2, more particularly under Provision C, thereof, recorded its conclusion in the manner expressed above. The same issue was placed before a 7-judge bench constituted to re-examine the position adopted in Sardar Lal case. The position came to be reversed. The court in Shamsher Singh declared that whenever the Constitution required the satisfactions of the President or the Governor for the exercise of any power or functions, as for example under Article 121.
So, no, that point is you have already made. It should not be personal satisfaction. It has to be on the aid and advice of the Council of Ministers, isn't it?
Yes.
So that point you don't have to press upon. It has to be on the aid and advice. So
Yes.
your only point is that the Council of Ministers in the instant case, they have not aid and advised him to dissolve the
Yes.
this thing. Okay,
Yes.
they have given a
To
opposite.
give opportunity to from the government is the
that
advice.
is, so that's your point.
Yes, because the law is very clear. Yes.
So this, what you're reading, it's only that it is not the personal satisfaction of the
Yes.
governor, but Council of Ministers.
Yes,
On that
that's-
point, you don't
that's
have to
true.
press. You don't have to press that point because we know it's clear.
Yes, it's clear. My lord, I'll not read, but I would like to draw your kind attention only because this is Milai Licha, is specifically passed by 5 judges bench of the Constitution. The fact
It is
that
not personal satisfaction
yes,
on
that
the
is
aid
true.
and advice.
Yeah, it has to follow act and advice of the councils of ministers.
So your point is that now in this case, the Council of Ministers had advised otherwise,
Yes.
but the governor had
Yes.
gone ahead anyways.
Yes, my
So
lord.
that's your point, huh?
My lord, at least I'll just
How?
cite
Which
Yeah.
para?
the para only. Milai 2000.
Okay, yes, citation 2000,
Citation is 2005 volume 2,
2005, huh?
SCC 92,
Para
para 12
12, yes.
and para 14 and 15.
Oh. Same distinct principle?
Yes, same
Not
principle.
personal
The government has
satisfaction?
to act upon on the advice and of the
Yes.
councils of ministers.
Okay,
And
same.
18 is very relevant also
Huh,
here.
okay, so you can read one para if you
Yes,
feel you require. Para 18.
yes, para 18.
Oh. What does it say? Same?
My lord.
Not personal satisfaction, but
Para,
has
yes,
to be.
the last one is that under the cabinet systems of government embodied in our constitution, the governor is the constitutional or former head of the state and he exercises all his power and function conferred on him by and under the constitution on the aid and advice of his councils of minister. This is what I want to.
Yes.
But my lord, the fact is a bit different. Here is that in respect of this thing, terminations of nominated member, in this Milai Souza, nominated member can be terminated in all course because they enjoy that with the pleasures of the governor. But the point is that in this case,
Okay, the case concerns to termination of nominated
but in
member.
this case, the difference is that councils of minister advice was there, it was placed before him, and he acted in pursuance to the advice of the councils of minister. The difference is that this is autonomous district councils. The Supreme Court also took very serious these matters since it pertains to administrations of 6th schedule. But in this case, the difference is that though here aid and advice was sought, but it was not acted upon, in contrary that the governor had acted. Because here the law is very clear, he has to act and advise of the governor or the councils of minister. This is what my point.
Okay, para 18.
Yes. My lord, and then another point is that, my lord, recently there's judgment passed by you, because my prayer is not only setting aside this in twin notification 77. My prayer is also to direct the governor to conduct floor tests as per pursuant to the advice of the councils of ministers.
That's your prayer?
Yes, the last prayer.
Oh, okay.
So, my lord.
This is concerning your prayer.
Yes. My lord, in this case also, it is very clear.
Floor test.
Here, Vizir Sangakis recently you pass it, and that very narrow margin, just by only 2 MDC in this case. And the governor passed this thing in twin notification to invite to form a government.
So, this is, so floor test was conducted here?
It was conducted. It was conducted.
So already no problem in Lai autonomous,
yes,
isn't
yes,
it?
Yes, it should not be.
Everything settled.
Yes, it's settled. And my lord, I'll read, you know the fact of the case, it might still be fresh in your mind. I'll just read the last para, because my prayer is that to direct for floor test also.
Similar order.
Yes, my lord, allow me to read 46. Just
46.
only two paras.
Okay.
The apex court in Chandra Kheslar Union of India has observed the following, passed the following order. During the course of hearing, we are satisfied that instance-sensitive and contentious issue raised on behalf of the petitioner can be resolved by the simple direction, requiring that holdings of the floor test at the earliest. Holding the floor test would remove all possible ambiguities, would result in giving democratic process, require credibility. We therefore direct that all the prerequisite formalities for holding floor tests, including the formalities required to be completed by Election Commission, to be completed by 15/3/2017. We request the Governor of the State of Goa to ensure that a floor test is to be held on such and such. The only agenda for the day would be holding of a floor test to determine whether the Chief Minister administered the oath of office has supported the majority. The floor test shall be held on such and such as early as possible. This is your Lordship judgment passed by 17. Thus, considering the peculiar situation that has arisen in this instant case, this court finds that it is imperative for the writ petitioner to prove that he has the majority support in the House in terms of Rule number 21.5 of LADCCCB, Rules 2010, as stimulated in his appointment that such and such before he take up any executive decision. Accordingly, in view of the decisions of the apex court as discussed above, this court finds it appropriate to direct the petitioner to go through the floor test in terms of 21.5 of LADCCCB Rules 2010. Thus, all the stakeholders are to take immediate necessary steps to ensure that a floor test is held for the petitioner to prove that he has the required majority support of the House within the outer limit of 2 weeks from the date of receiving certified true copy of this order. So, my lord, my
similar order be passed.
Yes, my point is that
praying.
even their conduct rules are one and the same. That article, my first point is that being they having absolute majority, that article Rule 22 has come into play. Instead of that Rule 22, this is 21. It's everything is same. So then the petitioners are entitled to form the government, or at least to conduct, has to be given an opportunity to conduct floor tests in view upon the advice of the councils of ministers and by this order itself also. My last contention is that S.R. Bomaya, I have given the very last page, 434. Just this is the conclusion. The very brief fact is that Mr. Bomaya, Janata Dal Party was coming to power. It was toppled, and Bomaya was relief, and he was removed from the CEM. So he could not conduct floor tests. And the Maharashtra, the governor proclaimed governor rules, and then the same was challenged before High Court. He lost it, and again it came up before Supreme Court. And during that turbulent periods of time, it was passed by 9 judges bench. It's happened in many states. Nagaland, Arunachal, Meghalaya, in many states in India, then where the governor proclaimed emergency. Here is the decision in para 434.
Para
Because
434.
because only proclamations of the governor rule, president's rule can be done with the aid and advice of the councils of ministers. This is the law. And Chief, my lord, we may summarize our conclusion now. Article 356 of the Constitution confers a power upon the president to be exercised only where he is satisfied that a situation has arisen where the government of a state cannot be carried on in accordance with the provisions of the Constitution. Under our Constitution, the power is really that of the Union Councils of Ministers with the Prime Minister at its head. The satisfaction contemplated by the article is subjective in nature. My lord, and here it is very clear that this is the Councils of Ministers and Cabinet Ministers in one and the same. And then the reason why this notification was issued in their counter affidavit is that the minister.
Yes, it's okay. Facts of the case, I think I recollect.
Yes, because here the minister of respondent number 2, District Council and that Minority Affairs, believe that there will be change of the government. And the governor, they specifically mentioned that the chief minister orally advised. Well, that is very pertinent here to submit here. This is my point. In the counter affidavit by the state respondent.
Okay, counter affidavit
Yes,
of state
yes.
respondents.
I would like to read that.
Para?
Manut Para 2. He takes number 8.
State respondents will be 1, 2, 3, and 5,
Yes.
isn't it?
Yes.
Page number 8 of the
Yes.
counter.
Yes. So, may I read from?
It starts from which sentence?
Actually, I would like to read from the middle of page number 8. That is why that impugn notifications was issued. The Honorable Minister, may I read?
Wait.
It's
Where
1,
is
2,
the-
3, 4, 5, 6. From 13. Page number
Yes,
8.
yes. Okay, the Honorable Minister.
Yeah, the Honorable Minister, DC and MA, has mentioned in his concern that there may be another change of government since it is obvious that CIDC lacks political stability, and it would seem that either suspension or dissolution would be the best course of action. And again, this is the Honorable Chief Minister has also mentioned that the political behaviors of the members of CIDC are most unpredictable and stability is a matter of serious concern. Though there is nothing in record and writing, this is one of the reasons that he proclaimed this emergency, believing that there will be political instability. Though I mentioned in my first ground that political instability is not the ground to proclaim dissolution, and this is the reason. As I have mentioned that, specifically I have mentioned that, if this is the reason, how can they proclaim that dissolutions of the CIDC?
Okay, but you're not really specifically denying that there could be political instability. That, for you, you're saying that there could be political instability, but political instability is not one of the grounds.
Yes.
That's your point.
Under 20 BP,
So you admit that there is political instability.
my lord, it is on record that 2 times there have been change of the government.
So there is political instability.
But
Okay,
that
fine.
political instability cannot be the ground
But cannot
to
be a
dissolve
ground.
CIDC.
Yes. Anything else?
Then that I have not completed Bomaya case, Lordship. I'll continue. Bomaya. And number 2.
In para 343 and which para?
For sub para 2. I have read 1 and point number 2. The power conferred by Article 356 upon the President is a conditioned power. It is not absolute power. Existence of the material which may comprise or include the reports of the Governor is a precondition. The satisfaction must be formed on the relevant materials. Recommendations of the Sarkara Commission with respect to exercise of the power under Article 356 do merit serious consideration.
Just hold on. Come back to the page where you're showing me. Don't change the page.
296.
Yes. Yes, please continue. Subpara 2,
Subpara
isn't
2.
it? Yes.
The power conferred, are you there, Lordship?
Yes.
By Article 356 upon the President is a conditioned power. It is not an absolute power. Existence of the material which may comprise or include the reports of the Governor is a precondition. Satisfaction must be formed on relevant materials. The recommendations of Sarkaria Commissions with respect to exercise of the power under Article 356 do merit serious consideration at the hands of all concerned. 3. Though the power of dissolving of the Legislative Assembly can be said to be implicit in clause number 1 of Article 356, it must be held, having regard to the overall constitutional scheme, that the President shall exercise it only after proclamation is approved by both houses of the Parliament under clause 2, and do before such. Until such approval, the Governor can only suspend the Legislature's Assembly by suspending the provisions of the Constitution relating to Legislative Assembly under subclause C of the clause 1. And the dissolutions of Legislative Assembly is not a matter of course. It should be restored to only when it is found necessary for achieving the purposes of the proclamation. The proclamation under clause 1 can be issued only where the situation contemplated by the clause arises. In such situation, the government has to go. There is no room for holding that the President can take over some of the provisions and powers of the state government while keeping the state government in office. There cannot be two government in one sphere. So, my Lord, 4 point is that the proclamation has to be taken place only when when the law specifies. That is my submission. My Lord, just to counter their counter affidavit very briefly, because they have not, their main point is that
their main point is political instability,
yes,
isn't it?
Yes. Well, look, what I would like to submit here is that the Governor, having anti-defection in his mind, anti-defection law would be applicable, though it was not applicable in view of the decisions passed by this court in three cases, also followed by Meghalaya judgment also. Because the Governor cannot suspend the particular MDC member. So he acted in this manner. What the law calls is that this is called colorable legislation. What cannot be done directly, the Governor had done this one indirectly. This is one and the same. My Lord, if you kindly see, there is judgment. Omnis moi chakma. Because, my Lord, the law is very settled in the state of Mizoram, not only in state of Mizoram, in Meghalaya also, in Autonomous District Council, in 6th schedule, there cannot be anti-defection. It was held by this thing omnis.
See, so anti-defection law. So, what is your point in
No, my point is here
case?
that because first it comes
they say in the counter affidavit that it is because of the anti-deflection
no, my
law.
Lord, they have not said that anti-defection, but in other language that they say that political instability.
So political instability.
Political instability.
So don't see what you feel could be the reason. Don't come into that.
No, my Lord.
They have. So your point is that there's no even if there's political instability, it does not cover under 20 BB.
My lord, from reading,
so come to your point. Huh?
no, from reading their counter affidavit, what they stated is that.
So they're saying that there's political instability.
Yes.
So you're saying there's no political instability,
Yes.
isn't it? Leave it at that.
My lord, yes,
Why
that is-
quote these judgments? Because we know the court is aware also
Yes.
regarding the anti-deflection law, whether it is applicable in the schedule, this thing.
So, my lord, reading their
basis or
counter
not. So
affidavit.
leave it at that.
Yes, reading their counter affidavit, that is their main point.
Their main point
because
is
the
here.
petitioner switched from this one before in MNA.
Nowhere did they mention that anti-deflection law is applicable and therefore this. So you don't have to
Yes,
elaborate your judgment on that point,
My
isn't
lord,
it?
But in their
Come to the
counter
point.
affidavit is that the allegation against the petitioner number one is that before he was MNF, again he switched to BJP, again he's going to switch to ZPM. That is,
Because of that, they're saying there's political instability.
Instability.
Bas, leave it at that.
yes. Then because of that, the governor took action and that passed the impugn order.
Yes.
So what my submission is that that the manner how the allegation make against is that it's same with anti-defection. So he cannot take action under anti-defection law. He passed this impugn order. This is my submission. Because omnismoy after that Shreku, after that in WPC 74/2024, LR Dingliana, Chinza, they are all followed. So what he cannot do directly, and action had been done indirectly, dissolving the CIDC is my submission.
Okay.
And my last point is that from their counter, annexure, they have enclosed some annexures, but I don't want to impugn any of the
So
annexures.
you're this thing, LR Dingliana Chingsa,
Yes.
this case,
Yes.
regarding anti-deflection,
And before
where I
also
was
Shreku
also
was
sitting
also-
in the bench.
Yes.
So all the old, this thing where I'm involved, just
It is
citing.
admitted
Anyway,
provision.
sir, koi.
Yes, my lord, kindly go to their this one 20, it page number 24,
24 of what?
their government or counter affidavit. 25,
Page number 25.
yes.
Oh.
This is the manner how the governor can exercise for dissolutions of the Autonomous District Council. Exactly. And this is one of the examples cited by the government. Here, what I would like to stress is that, here that the reason is that 16.2 they cited and all. Here, para 14 of the Sikh schedule. In this
Please,
case,
read, what is this about? Oh.
my lord, this is about recruitment of the employees in Sikh schedule. So relevant is that para 2, para 3.
Para 3, please read.
Whereas at the same time, the commission constituted under para 14 of the Sikh schedule has submitted its report stating that in absence of recruitment rules, a number of irregularity activities have occurred in the CIDC without following proper procedures. Absence of RR itself is violations of para 268 of the Sikh schedule, which states that there should be rule for appointment of staff of the district council. My lord, kindly see this one, para 14 and para 2. Because in that 20 BB, there are many in that list in which the governor can dissolve the autonomous district councils. Here, rightly, the governor pointed out in 2020, because para 14 is included in that 20 BB list. And again, para 2, see, it is also included in that list in respect of recruitment of employee without that RR. So, rightly, the governor in this case passed this dissolution order. But in my case, comparing my case, the governor exercised 20 BB and 16.2 on the grounds of political instability. That political instability is absent in that 20 BB. This is my point. While that para 14 and para 2, they are present. That is the governor, and the next one, the governor relied upon this notification 15 March 2024. wherein the governor dissolved LADC. In this case also, it is not disputed that the governor rightly invoked this sub-rule to Rule 23. He has discretionary power.
So you're saying that it's different.
It's different.
This is different
Yes.
situation here.
The
and
point is that
is
the
different.
governor
huh?
can issue, can dissolve
because it's covered
the
by
LADC.
20 BB.
Yes,
huh,
yes.
Okay.
But that the powers and the effects are different, entirely different. In my case, the governor has no power, has not been empowered to dissolve MADC, wherein there is no provision at all. On the grounds of political instabilities, that's my point, Lordship.
Yes, yeah. Huh. Anything, any other point, that's it?
My Lord, if you can allow me to rebut the counter.
Yes, yes. Yes, Mr. Deep. I cannot hear you.
Am I audible now?
Yes, now you're audible.
Before I go into the other details, I will try to make it as short as possible. I would first of all like to refer to Annexure 11, page 43 of the petition.
Okay, page 43.
I know it might be a repetition, my lord, but this is very important. Page 43 of the petition.
Yes.
Annexure 11. Decision of the Council of Ministers
Yes.
obtained by circulation. Proposal for obtaining opinion of the Council of Ministers for imposition of governor's rule within the Chakma Autonomous District Council. As per provisions contained in Rule 15 of the Government of Mizoram, Transaction of Business Rules 2014, as amended from time to time, the above proposal of District Council and Minority Affairs Department was circulated amongst the members of the Council of Ministers for opinion. The Council of Ministers is of the opinion that the new claimant for formation of a new council be afforded an opportunity by the government. However, my lord, there is a however. The Council of Ministers is willing to accept. This is very important, my lord. The Council of Ministers is willing to accept any decision made by the Honorable Governor, as it is a discretionary power. The Council of Ministers is mentioning that it is a discretionary power of the Governor to take action as he considers necessary. Now this, my Lord, I will most humbly submit before your Lordship that this has to be read along with 20 BB. Let us come to 20 BB.
Yes.
Come to 20 BB. Exercise of discretionary powers of the governor in discharge of his function.
Yes.
Now, my lord, I don't want to go into the details. Everything is there. Your lordship has just now gone through it. What I would like to refer to is of this schedule, shall. My lord has got it. Just 2 lines.
Yes.
2 lines from of this schedule, shall, after consulting the Council of Ministers, and if he thinks it necessary, the district council or the regional council concerned, take such action as he considers necessary in his discretion. Now, my lord, there is not a whisper in the Constitution or in the 6th schedule or in 20 BB that the governor has to abide by the advice of the Council of Ministers. It is a discretionary power. The aspect which relates to the advice of the Council of Ministers and thereafter the action to be taken, whether it is as per the Council of Ministers' decision, is absent. It says, take such action as he considers necessary in his discretion. That means, which has to be read that not according to the advice of the Council of Ministers. So as far as 20BB is concerned, it is absolutely the discretion of the governor.
Yes.
But the question whether the action of the governor is similar to that of Article 356, which was just raised by my learned friend. Now, 356 and 6th schedule should not be read together. 6th schedule is a different aspect which relates to Autonomous District Council and the discretionary power of the governor when it relates to 16.2 or 20BB. But 356, my lord, in case of 356, the President of India is advised by the Council of Ministers and the President has to act as per the advice of the Council of Ministers.
Okay.
So there is a lot of difference, huge difference, when it relates to 20BB, read with 16.2 and 356. We should not mix these two aspects.
Yes.
Absolutely a separate issue altogether. Now, my lord, the action taken on behalf of the governor, if your lordship can kindly come to my affidavit, paragraph 4, page 4, second paragraph. Paragraph 4, page
Yes.
4, second paragraph, my lord. That
Of
the
your
constant
counter affidavit, isn't it?
counter affidavit, my lord.
Counter affidavit, yes.
Paragraph 4, page 4, paragraph 2.
Yes.
That the constant political instability is found extremely detrimental for the Chakma Autonomous District Council, as also the other Autonomous District Council, and is certainly not what is intended by the 6th schedule of the Constitution, which envisions the effective administration of the tribal areas for the interest of the people, which is certainly not what is intended in the 6th schedule of the Constitution, which means it is certainly not as per the guidelines and the provisions mentioned in the Constitution in the interest of the people. So that was the reason that if there is a political instability, how can the Autonomous District Council serve the people's interest? There has to be a stable government. Until and unless there is a stable government, the interest of the people cannot be served. Now, my lord, I have just now pointed 20BB, which says it is a discretionary power of the governor. The Council of Ministers, the decision by which the Council of Ministers has left it to the governor, of course, with the specific mention that they should be given an option to prove their majority. Now, whether the governor should have considered that aspect of allowing them to prove their majority as per the advice of the Council of Ministers, which is apparently mentioned, I have just now pointed. Now, whether this particular aspect being not considered by the governor is a violation of the fundamental rights of the petitioner, that needs to be considered by your lordship.
But ultimately, Mr. Dev, ultimately, the majority, that has to be seen. Ultimately, that's a step that has to be taken by the governor. Whether
Exactly.
the whichever political party, whether they have majority or not, that is the ultimate step which has to be taken anyways, as per the what
I
was
agree.
observed by the Council of Ministers, isn't it?
I agree, my lord.
Maybe if it,
And that
even
is
if
why,
it was not done immediately.
and that is why my humble submission that the Council of Ministers has advised the governor twofolds. It's a twofold advice. One, that let them be given an opportunity to prove their majority in the House, whether they really have a majority or not, and whether they can lead the CADC and provide a
Yes.
permanent autonomous
Which
district
is
council
the
in the-
ultimate step that is required to be taken anyways.
and whether and the second option which has been given by the Council of Ministers is, as per the discretion of the governor, he can take any decision, which is there very much there in 20 pp. If it is read with 20 pp, the discretion of the governor is very much there, irrespective of the advice given by the Council of Ministers.
Yes, okay.
Now, whether the petitioner needs to be given an option to prove his majority in the House as per the advice of the Council of Ministers, or the governor is absolutely correct in exercising his discretionary power under 16(2) read with 20 bb, that is a matter to be considered by your lordship.
Now, what are the facts that led to the governor to conclude that there is political instability?
My lord, there is a political.
What are the thing?
There was a change in the autonomous district council since 2023 regularly. This was happening, and there was a change in the leadership, change in the political allegiance, and one after another this was going on. If my lord can kindly come to paragraph 4.
Beginning of paragraph 4. Okay, this is why
basically-
the governor concluded that there is political instability, isn't it?
Paragraph 3, well.
Okay.
I would rather submit, my lord, that paragraph 4 from the very beginning. From the very beginning. So this was basically the reason
Okay. Yes. Okay.
why the governor came to a conclusion that there was a regular political instability, and his discretionary powers should be exercised under 16(2) read with 20 pp. And that is why he referred the matter to the Council of Ministers for their advice, which is very much there in the Constitution, in the 6th schedule, in 20 pp, that he has to take the advice of the Council of Ministers. Now, whether he has to act on the advice of the Council of Ministers or not, that part, the Constitution is silent on that part. But the advice of the Council of Ministers, as we read just now, there are two advice. One, to allow them to prove their majority, and second, they left it to the governor to apply his discretionary power.
Yes. Okay. I
That's
got your
okay.
point.
Well, I think we can dispose of from Learned AG's submission, because he fairly submitted that.
Have you completed? Is that it? Anything else?
Let me, I have not yet completed. Now, my learned friend was referring to that fundamental right, Article 14 has been violated. I don't agree that fundamental right has been violated. The governor is very much entitled. Conclude, I would say, the governor is very much entitled. He is very much authorized by the Constitution to exercise his discretionary power. It cannot be read with 356. Here the governor enjoys a discretionary powers which he has applied under the provisions of 16(2) read with 20 pp.
Okay.
And that is what he did. Now, whether it was correctly done or not, whether he should have acted on the advice of the Council of Ministers or not, that needs to be decided by your lordship. That's all there.
Okay.
Although the Constitution is silent by now.
Yes.
That's all.
That's all. Yes.
My lord, as a secretary to the CADC,
CADC,
we don't have much. We don't have much to say, but other than the facts that has already been laid before this honorable court, but my only submission is that out of the 20 seats in the district council, the ZPM party has hold the majority of 17 seats. Yes, my lord, as of now.
So you are adopting the submissions made by the
Yes, my
learned
lord.
AG?
Yes, my lord.
AG.
Yes, my lord.
Okay.
Not just 2 points only, because I think even landed AG also, that he submitted that the opportunity should be given to prove their majority.
That is the advice of the
No, I have
Council
not
of
read
Ministers. Council
That
of
is-
Ministers
I have not read
advice.
that. I'm
Yeah.
sorry. I don't agree. I don't agree with my learned friend. I have not.
No,
I have not-
so I'm
What I have
saying,
said- what
what
I
you
have
have
said-
submitted is what the advice of the Council of Ministers, a suggestion,
Exactly.
huh?
Exactly.
Not what the AG said, huh?
Yes, so opportunity will be given, so that is, that I would like to counter. And then again, and that admitted there had been 2 times changes, but I don't admit that there would be another change in the government. So that is, I want to make it clear that. So it is admitted.
How can you predict that?
No,
Okay,
my
I
lord, we
think-
cannot go on a prediction. So even governor also cannot pass dissolution on prediction. That is also on the oral advice of
Okay,
minister.
fine. Okay, I've heard your submissions, I think.
And also, my lord,
what?
the last point is that just to reiterate what the landed government advocate general submission is that his submission is that the governor has discretionary power in view of 20 BP, and I have read that in Milai judgment and then
Yes.
para 28 and in
That's why he's
Nabam
countering what you have said.
Yeah,
No,
that
so you
is
don't
that
have to
The
repeat.
government has to act on the advice of the councils of minister. It is not his discretionary power, because that.
But you're missing one point, that he said
That is
that
applicable for
concerning
Article
the sixth
356.
schedule, it is different.
356.
Governor
That is applicable
and
for Article
President.
356. Not
Yes,
under the 6th schedule.
356.
Yes, I can say, my lord, and some of the judgment I refer 356. That is the power of the president, the governor. But the judgment I relied upon,
The latest.
the one, no, not only the latest one, Jayanta Rongpi. Rongpi, very specifically 6th schedule. Because here it is very clear, 356, all in the judgment.
So you have mentioned. No,
I have mentioned, but just to counter submission of AG,
Yes,
that
Jayanta,
he submitted
which
that
was
the
mentioned
power
as
under
judgment.
356 and 6 schedules are
Verification
entirely
learned
different.
counsel.
But this judgment was passed by 2 judges. My lord, if you see this, the heading of this giant, it was passed by UL Bhatt and RK Mishra Singh.
So where is the
Division
judgment? Have you given me a
I
copy
have
of
given
that?
to you Jayanta Rongpi.
Jayanta Rongbi.
Yeah,
So
1994.
you are rebutting the submissions made by the AG, saying that this is not correct because there is that judgment.
In
Okay,
this
leave it at
judgment
that.
clearly mentioned that in the middle of the judgment, what was that cited by Chief Justice Chandrachud, Bhagwat, all 356 was written, cited, and in the end, it was confined to 6th schedule. Then we cannot say that they are different, entirely different, since as long as DB of this Guwahati High Court referred that 356 judgment for setting aside of the impugn notification of the President's rule proclamation. That is my point. It is not
Okay,
different.
Fine. Oh. Anything else?
That,
That's it?
that's my priority. That
That's it,
my last submission is that even
Okay.
in my petition also they have no specific denial that there is no provision on the grounds that political instability.
You have
I have finished. That is my last point.
you are repeating yourself over and over again. That point
That's
is
my
there.
very good point, my first point.
So very good point, but you don't have to keep repeating it.
Yeah, that's true.
Okay,
That is my last point.
So many repetitions.
that's
We
true.
are taking a lot of time. Yes.
Yeah, that's
Heard
my last
Mr. J.C. Lalunsanga, Learned Counsel for the petitioner, along with Mr. B. Dave, Learned AG, Advocate General for the state respondents, and Miss
H.C. Deborah.
Deborah, Learned Counsel for respondent number.
I am assisted by Miss Mary Kyangte.
Yes, assisted by Miss Mary Kyangte, Learned Government Advocate. And Miss Deborah so-and-so, Learned Counsel for respondent number 4. Hearing concluded. Matter reserved for judgment.
That's your point.
Deeply obliged.